Thank you, Mr Speaker. I'm happy to take a brief call on the Family Court Proceedings Reform Bill. I just want to state at the beginning, members of Parliament, I guess any member of Parliament who meets regularly with people in their constituency office will deal with issues that are very sensitive and very difficult all of the time. And some of the most difficult ones that we deal with are where there's been a relationship breakup. I get people coming in to the office to talk through difficulties they have with the child support system, for example. It seems to take up an awful lot of time, and I acknowledge in that relationship breakups can be incredibly difficult for all involved. And so the changes that are being debated today around the Family Court Proceedings Reform Bill are actually incredibly important for us to get right, because families, when relationships break up, people need to have an adequate level of support. That's just an absolute bottom line. They've got to have an adequate level of support. And we also have to recognise that in relationship breakups there can be all sorts of external factors that create a huge power imbalance in the relationship that can be very difficult to work through. And so there are some aspects of this legislation, I'm not as familiar with it as the members of the committee, but there are certainly some aspects of this legislation, having listened to the debate, that concern me greatly. So, for example, if we take the removal of lawyers from large chunks of the process, on one level I might look at that and say, hey, that's actually probably quite a good thing, because if a family dispute is there, maybe it's better that it's not a legal proceeding, that in fact we get people together, we get them to sit down, talk things out, and that maybe getting lawyers involved makes things more difficult. But actually, a lot of the evidence suggests that by having a good process around things and ensuring that all of the parties to that process are well supported with good, rational, sensible advice, removed from the emotions of the situation, that in fact we get a better outcome. And in something like the family court, where the interests of children are involved, it's really, really important that everybody involved is adequately supported so that we can get the best possible outcome. This isn't something where we should make decisions based on saving a bit of money. Because in fact, if we get these things wrong, it's costly in a fiscal term for the country, but it's hugely costly in a whole lot of other ways for those who are involved in that process. So for the children and for the parents who are going through a separation or dealing with or who have been through a separation and are dealing with disputes, it's important that the process is right and that they get support they need. I'm really concerned with some of the reforms, for example, limiting the access to court-funded counselling at the time of separation. Actually, this is a time when we want to make sure parents have all of the support that they could possibly need in order to deal with the issues that are before them. Limiting the role of lawyers in the court and the processes of the court, and therefore limiting access to legal aid. What we have to recognise again, when a separation occurs or when a relationship breaks up, there can be huge economic disparities in the way things happen. So limiting access to legal aid can be very difficult for some of the parents. The establishment of a new process called the Family Dispute Resolution, that will cost around $900 just to get into it in the first place. Now, that is a big barrier for some people. And I think that we've got to really consider the cost that we're going to be imposing, that this Parliament, if this bill is passing, will be imposing on people who are at a very, very vulnerable stage. I don't think that that's a time when we should be imposing costs on them and making things more difficult for people who are going through this process. We should actually be doing all we can to support people who are having relationship and family issues so that they can resolve those satisfactorily, and so that people can then, particularly as I said, so that where children are involved, they can reach the best possible outcome. I am very, very concerned about the limited role of counsel for the child by raising the threshold for the appointment by the court. Children are the people who need to be the most supported in this process, and removing any level of support from children in family court proceedings cannot be good for those children. They should have as much support as we can possibly provide them. So overall, I wasn't a member of the committee, and I wasn't part of the debate in the earlier parts of these proceedings. So I look at it from a much higher level, perhaps, than those who are engaged in the detail. And I simply ask the House this question: will this leave children particularly, but also those experiencing family difficulties, better off, or is it about saving money? My analysis of reading what I've seen so far is that it's about saving money, and that is the wrong motivation for these sorts of changes.
Mr. Speaker.
David Clendon.
Thank you, Mr. Speaker. Mr. Speaker, I'd like to begin just by acknowledging and referring to the petition